I remember yelling, "Taser, taser, taser," and nothing happened. And then he told me I shot him.
Emotional testimony from former police officer Kim Potter as her manslaughter trial is set to go to jury this week. Potter is charged in the deadly shooting of 20-year-old Daunte Wright in April, when she says she mistook her firearm for a taser as he reportedly tried to flee a traffic stop. The prosecution claims Potter was reckless despite being trained on handling stressful situations. The defense argues Wright escalated the traffic stop and that Potter never intended to use deadly force. Wright's girlfriend, Elena Albrecht Payton, broke down in tears while testifying about Daunte's last moments.
Just kept saying, "Daunte, like, Daunte, like, just say something, please, like, just talk to me." And he just couldn't. Like, I know he tried, like, I know he wanted to. Because I replay that image in my head daily.
With closing arguments set for tomorrow, we're bringing in criminal defense attorney and former prosecutor Bob Bianchi right now. Compelling and emotional testimony on both sides. Bob, how will this raw emotion resonate with jurors? And what is prosecution? What about defense? What do they want the jurors to take note of?
Well, the defense is really doing an amazing job with this case, Arthel. What the defense is trying to say is that under the law, you have to remember there are going to be read jury instructions, and those jury instructions don't say you can criminalize an accident. It has to be where there's a conscious disregard for a known risk. For example, if you drive your car down the sidewalk where there's people and you may not intend to kill them, but you do, that would be a conscious disregard for a known risk. Here, the defense is saying this was not conscious at all, that she made a mistake that's made often with regard to mixing up a taser and a weapon, and she thought that she was tasing the individual. So that is not a conscious disregard for known risk. And the defense has done a good job by calling the former chief of police, who resigned because he did not want to fire Potter because he said that there were no rule violations there. It's a tragedy, no question about it. But he was saying it was a simple mistake. Potter's saying it's a mistake, and pretty much all the witnesses that the defense is cross-examining are coming up with that, including the expert witnesses. So I think that the prosecution's got a tough road to hoe here to get a conviction.
Now, Bob, you just said that that mistake happens all the time, where officers mistake their firearm for the taser. That gives me concern if that happens all the time.
Yeah, I don't want to say it is a common action error, as they call it. It is something where it's been documented before. It's not like it's happening every single day. It may be, I don't have the statistics on it, but it is something that the police community know is a problem, and that is why they have the weapons on opposite sides. They have them in different colors, because there's a recognition and a tense, interaction that was occurring here, which the defense is really playing up. I mean, they went into the scene. He was trying to flee. He had a warrant for a weapons offense, a domestic violence history, so that they're painting the picture. And I know this as being a former prosecutor of cops whose now attention span is in high gear here, and this action error of mixing up the weapons is unfortunately something that should be trained on much more, because it's not the first time it's happened, Arthel. And the bottom line to a criminal trial here is you could think it's bad and you could think it's horrible, and it is, because he should not have died. But they have to find beyond a reasonable doubt, and all 12 jurors, that she had a conscious disregard. And to me, if they believe that she did not think that she had a gun in her hand, and you see immediately after the incident that very compelling body worn cameras of the police officers, where she is so distraught and so clearly saying as an excited utterance, "I didn't know it was my gun. I thought I was tasing him." That's a tough case for the prosecution of subconscious disregard.
Now, you speak as a prosecutor for a second. I mean, because part of Kim Potter's testimony, she said, listen, I was training another officer that day. Quite frankly, given the caseload and all the precautions we're taking now because of COVID, honestly, if I wasn't training this other officer, I wouldn't have stopped that car. Who cares about a air freshener hanging on the rearview mirror, and who cares about maybe a traffic warning? She said that on the stand, that she wouldn't have stopped him. So how does that play in?
It plays in as a terrible tragedy. The reason why she said they made the stop was she was training this new officer, and the officer wanted to do it. So they had the probable cause to stop it. She typically would not have because of all the other issues they've got to deal with, but she thought it would be a good training opportunity. And so this tragedy was set off by that. I don't think that that's going to affect the jurors that much. I mean, listen, the defense has done a great job showing that Officer Potter had never had in 26 years a single complaint against her. She's a volunteer. She's a mom. She's got kids. And people may say, well, what does that have to do with anything? Well, what it has to do with, Arthel, and as a former homicide prosecutor, I'd be concerned about the idea that the jury may nullify, that is a real thing that goes on, a verdict. That is where they say, yeah, she violated the law, we find that, but you know what, given the circumstances, we just don't feel comfortable convicting here. So I think as a former homicide prosecutor, I'd be very concerned if I were handling this case that I would not be getting a conviction in it.
It's definitely just sad, no doubt, across the board. It's just very sad, very sad. I do want to change gears to talk about another case that's also heading to the jury this week. It's the sex abuse trial of British socialite GHISLAINE Maxwell. Prosecutors argue Maxwell groomed minors to have sex with her longtime friend Jeffrey Epstein. Some of the alleged victims testify that Maxwell also took part in the abuse. The defense claims these allegations are decades old and that the accuser's memories are unreliable. So what do you think just in general in terms of what's happening in that case, in that trial?
You know, Arthel, this is a vexing case to try to analyze because there's no cameras allowed in federal courts, and we have to go on what the pool reporters and reports of other people are. But here's my feeling on it. The defense is trying to argue that their memories faded and they have an incentive to test the lie, as they call it, because of money reasons. But the fact of the matter is, while the defense was able to poke holes in some of their story, you have 4 separate women coming in here who are pretty much giving the same grooming story. Maxwell was involved in getting them in the presence of Epstein. Then there's the foot massage. The foot massage turns into something sexual, and money is exchanged, and requests are made to get other girls. There's just consistency across the board with each of these witnesses. So I think GHISLAINE Maxwell is in serious trouble with respect to that, and I think that's one of the reasons she didn't testify.
Bob Bianchi, we leave it there. Thank you very much for joining us today. We'll take a quick break. We'll be right back. Thanks.